Hello everyone and welcome to Rajput, Jain and Associate. Today in this video we will discuss about the conversion of private limited company into a public limited company. So first of all, it is important to know the reason for conversion of a private limited company into a public company. So the first one could be raising of capital. As the name suggests, a private company finances its operation through private funds in the form of funds from its shareholders, investors, venture capitalists, etc. However, based on the sector and performance of the company, it can reach a stage where it needs a huge infusion of capital to expand, scale up operations or various other reasons. Next comes it improves the credibility of the company. If a company is listed on a stock exchange, then you can be assured of a few things like the transparency of financial data, since the SEBI asks all the companies to report all its financials periodically, and it also helps in better management. Hence, once a company goes public, its credibility usually improves. Next one is it helps in assessing the company's market worth. When a stock is listed on the exchange, it is worthy only what an investor is willing to pay for it. Hence, it improves an insight into the company's market worth. A company that has a good market worth can attract good talent and better options for acquisition as well as mergers. It also gives greater market visibility. When a company launches an IPO, it garners attention from the public. People who have never heard about the company but invest in the stock market start researching about the company and assess its financial, and hence it helps in gaining market exposure. Now, having discussed about the reasons for conversion, we now come on to the mandatory requirements for the conversion of a private company into a public company. First one is the name clause. The name clause in the Memorandum of Association is required to be amended to exclude the word private. After this comes the alteration of memorandum and article of the company as per the Companies Act provisions being provided under section 18(1). After this, an application is required to be made to the registrar of companies for the conversion of a private company into a public company, and the same has been provided under section 18(2) of the Companies Act 2013. Next, the company is required to have a minimum of 7 members as per section 3(1)(a) of the Companies Act 2013. Apart from this, the number of directors shall be increased from 2 to 3 in case of public company. Lastly, the company must have filed their annual returns or the financial statements before the applicable due date and must not have failed to pay or repay its matured deposits, debentures or their interest thereon. Now, having discussed about the mandatory requirements, now let's discuss about the procedure to be followed for conversion. So, for the conversion of a private company into a public company, the following procedure be followed. The very first step is convening of a board meeting. At least 7 days prior board notice be issued for calling of board meeting, and the said notice be served to all the directors of the company at their designated address which is registered with the company. Next, along with the notice, an agenda be attached along with the notes to agenda and draft resolution with the notice. After that, holding of the board meeting is to be made and the company shall consider the proposal of conversion. Then comes the passing of the necessary board resolution for the approval of conversion of company into a public company. After this comes the authorization by the company secretary or any director. So the company secretary or any other director is required to sign and file the relevant form with the registrar of companies and to do such acts, deeds and things as may be necessary to give effect to the board's decision. Next comes the fixing of the day, date, time and venue of the general meeting for the approval of conversion. Now, they need to approve the draft notice for the convening of the general meeting, and the notice be served along with an explanatory statement as per the provisions of section 102 of Companies Act 2013. Also, they need to authorize the director or the company secretary to sign and issue the notice of general meeting. Next comes the preparation and circulation of draft minutes, which is to be made within 50 days from the conclusion of the board meeting, and the same shall be served either by hand, speed post, registered post or email to all the directors for their respective comments. Next step is convening of general meeting. Notice of general meeting shall be served at least 21 clear days before the actual date of the meeting, and the same be served in writing either by hand or by ordinary post or speed post or by email. Also, a shorter period notice can be served provided the same is approved by at least 95% of the shareholders and the same is in accordance with Section 101 of Companies Act 2013. After this, the notice of the general meeting be sent to all the directors, members, auditors, secretarial auditors, debenture trustees and any other person who is entitled to receive the same. The notice shall specify the date, time and full address of the meeting venue and shall contain a statement on the business to be transacted. After this, the directors or the company secretary is required to hold the general meeting at the specified place and time and is required to pass a special resolution for the conversion of the company along with the alteration of memorandum of association and the article of association. Next comes the preparation of minutes of general meeting. The general meeting minutes be prepared and the same shall be signed by the signing authority and be compiled accordingly. Next step is filing of Form INC 27 with ROC. For effecting conversion of private company into public company, an application is required to be filed in E-Form INC 27 and the same shall be filed with the registrar along with the applicable fees within 15 days from the passing of special resolution. Now, this form is required to be submitted along with certain attachments like the minutes of the board meeting, the minutes of the members meeting, certified true copy of special resolution, altered memorandum of association, altered article of association and any other document as may be required. After this comes the filing of Form MGT 14 with ROC. So as per section 117 of Companies Act 2013, Form MGT 14 is required to be filed with the Registrar of Companies within 30 days of passing the resolution in the general meeting. Now, along with the Form MGT 14, the documents to be attached are first of all the certified and the true copies of the special resolution along with the explanatory statement. Next is the copy of the notice of the meeting that has already been sent to the members along with all the annexures. Next, a printed copy of memorandum of association and article of association. After this, the copy of attendance sheet of the general meeting and where a shorter notice has been provided, the consent for the same. Now, the next step is the issuance of new certificate of incorporation. So, on the approval of E-Form MGT 14 and E-Form INC 27, the registrar will issue a fresh certificate of incorporation with the changed name. Now, we come to the procedure that is to be followed after the conversion of company. First one is that the alteration is to be made in the memorandum and the article of the company and the same shall be noted in every copy of the memorandum and article as the case may be. Second one is that the company shall print the new altered memorandum and article of association with the new certificate of incorporation. Apart from this, the company shall paint or affix its name and the address of its registered office and keep the same painted or affixed on the outside of every office or place in which the business is carried on. The company shall also get its name, address of its registered office and the SIN number along with the telephone number, fax number and email ID printed in all its business letters, billheads, letter papers and all other publications. Also, the company shall have its name printed on promissory notes, bill of exchange and such other documents. Apart from this, they need to send the new address of registered office with all its banks, authorities and other basic utility service providers as applicable. The next comes the filing of necessary amendment application under the different acts. These includes Goods and Service Tax Act, Shop and Establishment Act, Factories Act, Interstate Migrant Workmen Act, Private Security Agency Act, Employee Provident Fund, Employee State Insurance Fund, other labor laws and industry specific laws. So this is how the conversion of private company takes place. For any query, please contact Rajput Jain and Associates. Thank you.